Under the Indian Penal Code, IPC, drunkenness can only be used as a defense against criminal liability in very limited circumstances, specifically when the intoxication is involuntary, meaning the person was not aware they were consuming intoxicants or were forced to do so, and as a result, were unable to understand the nature of their actions. This principle is outlined in Section 85 of the IPC, which states that nothing is an offense which is done by a person who, at the time of doing it, is, by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong, or contrary to law, provided the intoxication was administered without their knowledge or against their will. Key points about drunkenness as a defense under the IPC. 1. Voluntary intoxication is not a defense. If a person chooses to consume alcohol or drugs, they cannot use their intoxication as a defense against criminal charges, even if their judgment was impaired. This is based on the principle, qui peccat ebrius luat sobrius, which means, he who sins when drunk must be punished when sober. 2. Section 85 of the IPC. This section specifically deals with involuntary intoxication and outlines the conditions under which it can be used as a defense. The person must be incapable of knowing the nature of the act due to intoxication. The intoxication must have been administered without their knowledge or against their will. 1. Burden of proof. The accused bears the burden of proving that their intoxication was involuntary and that they were unable to understand the nature of their actions. Example scenarios where intoxication might be considered a defense. Someone is unknowingly given a spiked drink and commits an offense while under the influence of the unknown substance. A person is forced to consume alcohol against their will and then commits a crime while heavily intoxicated. Important considerations. Mens rea, guilty mind. Even when intoxication is considered as a defense, the court will still assess whether the accused had the necessary mental state, mens rea, to commit the crime. Severity of the crime. In cases of serious crimes like murder or rape, courts are less likely to accept intoxication as a defense, even if it is involuntary.